I will continue to talk about more on the related provisions in Part 12. The Part 12, which is on company administration and procedures. With this definition of financial year, we've now changed the requirements to hold an AGM from the current Section 111 of Cap 32, requiring holding of AGM in every calendar year. Instead, under the new CO, the requirement is now to be held for each financial year. So this applies to all companies. And the period within which the AGM is to be held is also made by reference to the financial year. So the period is actually the same. For a private company or a guarantee company, the requirement is to hold the AGM within 9 months after the financial year. And for a public company and a private company that is a subsidiary of a public company, the period is shorter, is 6 months from the end of the financial year. But the period is the same, but it's made by reference to the financial year instead of by reference to each calendar year. For a company's first accounting reference period under the new CO, and if the period is longer than 12 months, the requirement is to hold the first AGM within a period of 9 or 6 months, depending on the type of company, after the anniversary of the company's incorporation, or 3 months after the end of the financial year, whichever is later. This is to ensure that the period is not unduly long, because the first financial year may be longer than 12 months, and there is still requirement that it must be held no later than 3 months after the end of the first financial year. Well, companies may decide not to hold AGMs if certain conditions are satisfied. First of all, if they have decided not to hold an AGM by doing everything by way of written resolution. So there is no need to hold a physical meeting if everything is done by way of written resolution. For a single-member company, there is also no need to hold an AGM. And members can have a unanimous resolution or written resolution to dispense with the holding of AGM. This can be by reference to the coming financial year or all subsequent financial years. A copy of this resolution has to be filed with the company's registry. Also, a dormant company need not hold an AGM. So even though an AGM is not required to be held, there are still certain conditions that the company, certain actions that the company still have to take. First of all, the appointment of auditors. The directors can appoint auditors, the first auditors for the company where the AGM is not held. And for other cases, like if you have a single-member company or AGM is dispensed with by unanimous resolution, the financial statements and the audit reports and directors' reports, they are required to be sent to the members. They are not required to be laid at AGM, but they have to be sent to the members instead. And the current auditor for an existing company, the current auditor will be deemed to be reappointed. There is nothing to be done if no AGM is to be held. But there are situations where there will be no deemed reappointment, like if the auditor declines reappointment, or if the company's articles require that there must be an actual appointment instead of a deemed appointment. So members can also request the directors to hold a meeting, even though it has been dispensed with, provided that the members holding at least 5% of the total voting rights, they follow certain procedures, and they can request the company to hold an AGM. The next one is on how to require an AGM to be held after it's been dispensed with. So any member can require the company to hold an AGM by giving a notice to the company that has to be not later than 3 months before the end of the statutory period for holding the AGM, so leaving enough time for the company to prepare for an AGM. So there must be at least 3 months' time. The unanimous resolution to dispense with the holding of AGM can also be revoked by an ordinary resolution. There are also certain transitional provisions for existing companies. So, for example, if before the commencement of the CO, a notice of meeting has already been held, the existing provisions under the Cap 32 shall continue to apply to that meeting. So everything the procedures have to be followed as under Cap 32. So these are the provisions that are specified in Schedule 11. There are more detailed provisions in there. Next, I will talk about the requirement to lay accounts at the AGM. So now accounts are to be laid in respect of each financial year, but not in each calendar year. Under Cap 32, the requirement is that the accounts shall be made up to a date not more than 6 or 9 months before the meeting, the AGM is held. But now under the new CO, the requirement is that the AGM has to be held within 6 or 9 months after the end of the financial year. The 6 or 9 months depending on whether you're a private company or a public company, as I said previously in my slides. Next is, yes, as I said, it's 9 months after the financial year. For public company, it's 6 months. So it's the timing is also by reference to the financial year as with the AGM requirements. And the period for sending out reporting documents, as we've just said, is financial statements, the director's reports, and the audit reports. They are also to be sent within the same months, i.e. 6 or 9 months after the financial year. There are some other minor changes. Under the current Section 115A of Cap 32, there are provisions that enable members to request the company to circulate a proposed resolution at an AGM. Under the new CO, there are similar provisions, but the company has to bear the expenses of circulating the proposed resolution and any statement that the members wish to circulate together with the notice of meeting, provided the notice of the proposed resolution is received in time for the company to send out together with the notice. So in that case, the company will bear all the expenses of the circulation. There are also provisions under the new CO, this is a new one, which enable a company to hold a general meeting at different places using technology that will enable the members to exercise their rights to speak and to vote at the different venues of the meeting. Now, I think we are all very interested in learning more about the annual return. Now, for annual return, as I said, everything is now made by reference to the financial year instead of each calendar year. This is for public company and guarantee company. For private company, there is no change. The requirement is to file the annual return for a private company is to file an annual return after 42 days of the anniversary of its incorporation. But for a public company, it is within 42 days of the return date. What is the return date is now specified in Section 662. The return date for a public company is 6 months after the financial year, and for a guarantee company is 9 months after the financial year. So if you take an existing public or guarantee company, so the new provisions, the new requirements concerning the filing of annual returns will take effect at least 18 months from the commencement of the new CO, it is because the first financial year begins after the commencement date. As Christine has just given examples, for the straddling financial year, the old provisions still apply. For new financial year, it must commence after the commencement date of the new CO. So usually a financial year is 12 months. So you have 6 months or 9 months after the first financial year to file your annual return. So you still have ample time to prepare for your first annual return after the commencement of the new CO. As I said, for private companies, provision is exactly the same. For the contents of annual return, they are actually substantially the same, except that for a listed company, instead of listing out the names of all the shareholders, you are now only required to list out the shareholders which hold 5% or more of the issued shares in any class. Well, there is another thing that concerns the residential address and the identity number of the directors and the company secretaries. You know, there are provisions in the new CO which enables the company's registry to mask the full ID card, not the full, certain digits of the ID number of the directors and the company secretaries and the residential address from public inspection. But since there has been a lot of objections and different opinions expressed earlier this year while we were preparing the subsidiary legislation, we have decided to shelve the plan for the time being. And the relevant provisions on this masking of the ID numbers and the residential address, they will not be commenced together with the rest of the new CO. So these provisions will have a deferred commencement date, and we will have a review of that after taking into account all the views expressed by different stakeholders, and then we will let everybody know what we will decide to do after having a review. So certain sections in the in Schedule 6, which concerns the contents of annual return, they will not be commenced. That's essentially the provision of correspondence address and the ID card of the directors. There is quite an important change as regards the filing requirement for a guarantee company, which claims to be a private company under the existing CO. Because there is no such thing as a private guarantee company anymore under the new CO. All guarantee companies, they are now in a separate category, and they are all required to file together with their annual returns the financial statements with the company's registry. So this has to be complied with under the new CO. So all public companies and guarantee companies have to file their reporting documents together with the annual return under the new CO. This applies to the first financial year, which commences after the new CO commences. We've talked about all the annual returns and company administration. Now I want to turn to something which is concerns directors more than company secretaries. Currently, corporate directors are not permitted except for a private company, other than a private company that is within a group where a listed company is a member. Now, under the new CO, we require that all private companies must have at least one natural person as a director. All corporate directors are abolished for public companies ever since last amendment is 1984. I'm not sure quite exactly which year we abolished the corporate directorships for public company. Now, this new provision concerning at least one natural person as a director applies to private company. I'll talk briefly about the director's duties. Under the current CO, there are no provisions concerning the standard of director's duty. And we've reviewed legislation from different jurisdictions, and we've decided that for a proper guidance to directors, we will provide a statutory standard for a director's duty to exercise duty of care, skill, and diligence. This is a mixed test of subjective and objective test. The subjective test is that you have, if the certain director possesses certain knowledge, he is expected to use that knowledge and skill in the discharge of his duty. And there is the objective test, which expects all the directors to have the general knowledge, skill, and experience that may reasonably be expected of a person carrying out the functions carried out by the director in relation to that company. So it's specific to the function of that particular director. This is called the objective test because of the reasonableness required in the standard. So this duty replaces the common law rules as regards the duty to exercise care and skill. There are also provisions on the indemnification of offices against liability to a company. Currently, under the CO, there is a provision which covers the exemption and the indemnity of liability of directors. This is also directors and auditors. Under the new CO, there is a separate provision for directors and for auditors. As far as directors are concerned, if there are any provisions which exempts a director from liability for misconduct, for negligence or misfeasance, this is void. But there are certain provisions which allow companies to buy insurance for indemnifying a director, provided certain conditions are met. There are also certain provisions that permit indemnity against liability incurred by a director to a third party. But I'm not going to go into details to that as I think they are not of any real significance to your day-to-day work. There are also provisions on how to rectify the misconduct of directors, but the requirement is that the misconduct has to be rectified by the company in general meeting. But when passing a resolution to rectify such misconduct, the director himself and persons connected with the director cannot vote. And every vote by a member who is the director and persons connected with the director, all their votes will be disregarded when you count whether a resolution has been passed. And then I will also talk briefly about Part 11, which concern fair dealings by directors. There are provisions which govern transactions between a company and the directors, like the giving of loans by a company to its directors. There would be a conflict of interest, so there are rules that govern how a company can pass a resolution to authorize the giving of loans or enter into other transactions. For a public company or the subsidiary of a public company, the requirement is that if the company authorizes such transaction, the voting must be done by disinterested voting. So everyone who is interested in a transaction, I mean the director or persons holding shares for the director or persons connected with the director, they cannot vote in respect of this particular resolution to authorize the transaction. Now I will go to Part 13, and the most important provision in Part 13 is the headcount test. I'm not sure whether you are aware of this headcount test problem, which is associated with, in the case of the PCCW case, where the allegation of share splitting. Currently, under the CO Section 166, the requirement is that for certain schemes of arrangement and compromise, the requirement is that the resolution authorizing the transaction, authorizing the scheme, must be passed by a majority in number of the members holding at least 75% of the shares. The majority in number is so-called the headcount test, and the 3/4 in value of the shares is called the share value test. Both of these two tests have to be passed before the scheme can be authorized. After the scheme is authorized by the resolution, the company still has to apply to the court for sanctions. So the court may still refuse a certain transaction if the court thinks that it's not fair. But then there are oppositions to this headcount test, and especially from the listed companies and some other organizations. So we have reviewed the requirement in other jurisdictions. In Australia, they have added a new provision which says that the court can dispense with this headcount test in appropriate circumstances. Like, for example, if there is evidence that there is share splitting. So we have introduced this new provision into our new CO. But while the Companies Bill was going through the LegCo, there are suggestions that we should abolish the headcount test altogether. So we have modified the approach, and we have adopted a middle ground. So for certain transactions like takeovers and share repurchase, these schemes, the headcount test is abolished, but it's replaced by another test which we basically follows the rule in the Takeovers Code issued by the SFC. It requires that the voting must be the resolution that authorizes the scheme. There must be not less than 10% of disinterested members voting against the scheme. So apart from the share value test, the company has to still pass another resolution still has to pass this test of the 10% no disinterested member objection requirement. There are also provisions enabling companies which wants to amalgamate to have a court-free environment to do amalgamation. Currently, under the CO, everything, all amalgamations have to be done through the court. So you need a court sanction if you want to amalgamate. But under the new CO, there are provisions which facilitate amalgamation for companies within a group. These apply to wholly owned intra-group companies. They just have to pass certain tests. And then there can be amalgamation without the court sanction. There can be two kinds of amalgamation. It can be vertical amalgamation. That means between a holding company and its subsidiaries, or one or two subsidiaries or more. Or horizontal, just amalgamation of subsidiary companies. But there are certain procedures to follow, and they are detailed in this slide, and I don't want to go into any further details. That's all the major items that I would like to talk about. And if you want more information, you can go to our website. There are lots of material now available in our website. And in due course, we will be issuing letters to all companies highlighting all the major changes introduced by the new CO. And we will also make available pamphlets and booklets and for public, for interested parties to look at, to find out more information. And later on, there will be a hotline set up for members of the public to ask us questions or make inquiries, and it will be manned by people who know how and will give you more information on the new CO.
So thank you very much, Karen, and also Christine, for your presentation.